All right, hello everybody. Thank you for joining us today for our Wednesday webinar with the lovely Sunira Chaudhri. Just a little bit of housekeeping. We will be recording, so if you do not wish to be part of this recording, please feel free to turn off your camera. We do ask that during the presentation, you do keep yourself on mute, but during the questions and discussion periods, you're more than welcome to unmute yourself and ask your questions. If you do not feel comfortable doing so, please feel free to put your comments in the chat and I will relay them to Sunira. Otherwise, Sunira Chaudhri is the partner at Workley Law, and she will be today presenting on independent contractor or employee, how to make the correct decisions to reduce liability for your businesses. Otherwise, take it away.
Thanks, Kylie. Good morning, everyone. I know we're a small group today, so I will be moving through the slides one at a time. Happy to take some natural breaks. So what I'm going to be doing is going through each section. At the end of each section, I'm going to stop and ask if there are questions. However, if you want to throw that question in a chat for me to address, happy to do that then right at the end. So I'll make sure there's also time towards the end, but I'll have some natural breaks during the presentation as well. And I'm going to go ahead and share my screen. Okay, so as Kylie mentioned, today we're talking about independent contractors versus employees and how to make the correct decision to reduce liability for your business. I am an employment and labor lawyer. I've been practicing I'm in my 13th year now, my goodness. So yeah, definitely been a long time, and I'm a litigator. So with respect to the kind of work I do, I essentially work with employers and employees when it comes to all employment related issues. So if employers are looking to terminate an employee, introduce new policies to their workplace, sometimes we have new pieces of legislation that require new policies. So for example, electronic monitoring policies, a lot of employers rolled out remote work policies. So certainly work on things like that. Unionized employers, they may have grievances from employees that they have to deal with. We represent on the management side as well. And with respect to small businesses in particular, I love working with small to medium-sized businesses because there are a lot of new and niche sort of issues that face small businesses. A big one is employment agreements, writing that first employment agreement, figuring out, which is the topic of today, figuring out if somebody should be working with you as a contractor versus working with you as an employee. What are the pitfalls? What are the pros and cons of each? So we're going to talk about a bit about that today. Small businesses also need some help sometimes with dealing with employee complaints, whether or not they have to conduct an investigation. And so that can be helpful, creating policies, of course, as I mentioned before. But a lot of the tricky things can happen when you may have to terminate that first employee or the first few employees. If you have performance-related issues, if there's a discrimination-related issue, it can be very tricky and distracting to deal with a departing employee in a way that doesn't disrupt your business. So I find that some of my best work and most fulfilling work can often be when working with small businesses in helping minimize the disruption, especially when there's a labor related issue. So that's sort of the background. And I love employment law so much. I actually write an employment column every weekend. It's in the Toronto Sun. You can see it online. And it's a really great tool, I think, for business owners and employees, because I often write about trends in employment law, recent cases. I have a lot of interest in AI and how AI might be changing the workplace. So every week I usually pick a different case or a different topic and write about how it impacts the world of business owners, employers, and employees. So moving on to what we're talking about today specifically, our agenda, talking about some definitions of what an independent contractor is versus what an employer is. Very important. So we're certainly, going to get there. And I think there might be a lot of questions around what an independent contractor is, what an employee is. If you have questions as I'm going through the definitions, throw those questions in the chat. I'll try to deal with them in real time. And also there's a hybrid here, which is what a dependent contractor. What is a dependent contractor? And dependent contractors often straddle the world between employment and between a true contractor. And we'll talk about how some of the case law has evolved in that place. Next, we're going to talk about legal implications of defining employees versus contractors. And most importantly, then we're going to get to the meat and potatoes, which is how do we reduce your risk as a small business owner. Now, let's go straight to definitions. And you'll see my funny little picture here because it's sort of a fork in the road. The fork in the road, when you start working with someone new as a business owner, is often deciding, should this person be an employee, or will my life be easier if I just pay them as a contractor? So let's talk about the practical implications of all of this, but let's start with some definitions. Now, an independent contractor is an individual or a business. So this might be somebody who's actually incorporated themselves, they have a business number, or it could be, Jane Smith, who's working as a sole proprietor, and they provide services to another party and or contract, but are not considered an employee of that employer. So what's a true independent contractor? I often say the work I do for clients is pretty much that of an independent contractor. You hire me to do work for you. I do it on my own time. I use my own tools. I'm not going to your workplace to do the work. We might schedule time together and you might give me a deadline for the work that I have to do for you. But I have my own place that I do my work. I do it under my own name. You pay me for the work I do. I mean, it's the same kind of relationship you'd have with a plumber or some tradesperson. Now, what's a dependent contractor? Dependent contractors are a type of worker who's not considered an employee, but they're economically dependent on a single employer for the majority of their income. Now, many people can relate to this. A lot of freelance workers can relate to this. So let's say as an example, we often see this in healthcare, for example, a nurse might start his or her own business and contract with a hospital, but could be free to contract with other service providers. Let's say, for example, they might work for a doctor's office as well, maybe provide some services to a private family, but 80% of the time they're working for a hospital. They may be deemed to be a dependent contractor because the majority of their income comes from the hospital. The hospital, however, doesn't mind or allows this person to be free to contract on the side. But often the majority of the work that a dependent contractor is doing, in fact, that is what you need to be a dependent contractor. You might have a couple of small projects on the side, but the lion's share of the work you do is for one entity, and that brings you sort of closer to that employer-employee type relationship. Now, what's an employee? This is pretty simple for most of us. Anyone that works for an employer under an express or implied employment agreement, and the relationship between an employee and employer is governed by federal, provincial employment laws. Now, why do these definitions matter? These definitions matter because sometimes we like to blur the lines ourselves. Sometimes parties like to set up their own business, work for another organization, 40 hours a week. It's the only work that they do. They call themselves independent contractors, but they look like an employee. They smell like an employee. They act like an employee. They have a coffee cup in the kitchen. They have their own workplace. They have the employer email, but they're still calling themselves an independent contractor. And so this is really the nub of what I want to talk about today, because sometimes parties will try to essentially cloak their relationship as though it's one of an independent contractor relationship, when truly that's not what it is. It's one of employer and employee, and talking about some of the pitfalls of misclassifying some misclassifying the relationship. And so now that we've gotten through the definitions, I'm going to go a little bit further into the land or the world of independent contractors. So why hire an independent contractor? What is it about that sort of classification that's attractive to employers? Well, you might hire an independent contractor to perform piecework. Piecework are like, projects or a specialized task. So an example could be graphic design, social media, or a consultant. And these are usually short-term projects. Contractors are responsible for supplying their own equipment and tools. They own their own operating expenses. They pay their own taxes. They pay their own insurance costs. And they mitigate the legal risk of wrongful dismissal claims or Ministry of Labor complaints for employers. So let's say a small business would often look for an independent contractor or freelancer type arrangement. Often people are doing this for marketing. So you may not want a full-time marketing professional. You may want somebody to do a few hours for you every week in social media outreach, as an example. You might hire a web designer, as an example. That might be somebody working for you a few hours a month. Bookkeepers are another really good classification for an independent contractor. So you may not have the budget to hire a full-time accounting person, but you may need someone to look at your books 6 or 7 hours a month. These are really much more in the safe zone of independent contractor like relationships. They're short-term projects, or they might be long-term projects, but they're really short in duration. So for example, I have an external bookkeeper. I'm a small firm. I don't have a full-time AR or accounting person in my firm. This person works for me about 6 to 7 hours a month. I don't know in particular when she's preparing the work for my firm, when she's doing my books, when she's preparing financial statements. I send her all of the work to be done. We have a general deadline of when things should be filed by and what she helps me with. But essentially, that's an independent contractor like relationship. And so she wouldn't call herself an employee of my firm. I'm not worried about her suggesting that she earns the majority of her income from me, because she certainly doesn't. She only works about 6 or 7 hours a month. She does work on her own computer. She doesn't have a workly email address. She pays her own taxes. If she has staff, which I don't think she does, but if she did, she would be paying insurance for those individuals as well. That's a true independent contractor like relationship. And what's a factor to determine, what are the set of factors to determine an independent contractor like relationship? Exclusivity to the employer. So in my bookkeeper example, my bookkeeper is not exclusive to me. She has a lot of clients. Okay. If she only worked for me, let's say as an example, I had 50 lawyers and she was essentially working 40 hours a week for me, and she had no time to work for anyone else, she'd be exclusive to me. And that would be a factor against being an independent contractor. Here, she's not exclusive to me, so it's a factor towards being an independent contractor. Control and discretion of the employer. So in this case, if I'm the one paying her bills, my bookkeeper, how much control do I have over the bookkeeper? How much discretion do I have over the way she does her work? Well, I have no control really. She could do the work that she does for me from 1 a.m. to 5 a.m. and I wouldn't know any better really, because it doesn't impact me, or where she's doing the work. She could be doing it from her home office or her workplace. And in terms of discretion around what tool she's using, I don't have discretion over what tool she's using. I know she uses QuickBooks, but I'm not providing her with tools. I'm not providing her with any guidelines. So again, the more control I have would tend to weigh more towards an employer like relationship and away from an independent contractor relationship. Whereas if I don't have as much control like I do in this scenario, it tends towards an independent contractor relationship. The less control, the more likely it is an independent contractor relationship. If I'm defining the hours that she's working, if I'm defining when she can take vacation, if I'm defining when she's doing work for me versus other clients, I'm exerting more control, and that's tending more towards an employer-like relationship. The next factor here is who supplies the tools and equipment. We've talked about this already. If I'm supplying, the desktop, and it's often not just the desktop or the laptop. It's I'm providing an office space or a desk space. I'm providing an email address. I'm providing maybe a uniform or business cards. These all are tending more towards an employee-like relationship and away from an independent contractor relationship. But my bookkeeper, she has her own shingle. She works under her own business name. She uses her own tools. She's very separate and apart from what I do. I'm simply a client. Whereas some independent contractors work solely for one organization. They actually wear a uniform. They have the email address, and they're simply invoicing these employers as though they're independent contractors. And that's actually tending more towards an employee-like relationship. The next factor is the worker's risk of business and the ability to profit from the venture. So in this case, of course, if you own your own business and you have a lot of clients, your risk of profit and loss is solely your own. Whereas when you're employed by somebody, your risk goes down, of course. So where somebody is really carrying the burden themselves, it tends more towards an independent contractor relationship. Where it's not, where that risk is more on the individual or the corporation you work for, it tends more towards an employee relationship. And then the degree of integration of the individual into the employer's business. So I've seen a lot of cases where an employer will say, this person's an independent contractor, they only invoice us, but this is somebody who's getting, birthday parties. They are being congratulated on their 5-year anniversary. They have email addresses. They're invited to the holiday parties. They again look like an employee, feel like an employee, but the organization is referring to them as an independent contractor. So again, really, if you look like an employee, feel like an employee, you're really integrated into the business, it's really hard to maintain an independent contractor-like relationship. Okay. And so I am gonna invite again, I just sort of covered independent contractor like scenarios. Any questions before I move on to the employee section? Okay, I don't.
I just
Hi.
have a thought. Oh, hi,
Sure.
sorry, not even here. Here it is. It's coming up.
There we go.
Sorry, yeah, I just wanted to know, because this has come up in life. When you want to break a contract with your contractor, and sometimes it doesn't always work out. So I always prefer to go with contractors that we have an open contract. I'm gonna use snow plowing, for example. Some of them want to be paid. They want the contract for the whole winter, regardless how many times it snows, and others get paid per snowfall.
Mhm.
So how do you suggest I prefer the open concept. I don't like getting tied up into a contract. So just wanted some thoughts on that.
Yeah, so often a written contract with respect to, for example, snow plowing could really be helpful, especially in governing the terms. For example, if you want to pay a fee for the entire season rather than paying per snowfall, is very helpful because it creates a pattern of and proof with respect to the nature of the relationship between the parties. So often when we don't have a contract, it can be hard to, for example, deny claims that a snow plowing company, as an example, would be a worker of the organization. Although I think another positive to having a contract, first of all, is setting the fee. So let's say, as an example, you want to talk about the whole season. there aren't going to be surprises about what that fee is going to be as long as you're paying pursuant to that contract. Because we all know working with vendors and suppliers, when we don't have a contract, we can get some sticker shock when we finally get the invoice saying, oh, no, this is not what I agreed to. This is not what I thought I was going to get. So I think laying out a fixed fee or an upper limit fee. So as an example, in the snow plowing scenario, we're going to pay you a flat fee of $250 a month. That's going to include up to 6 snow plows. You have a fixed level of certainty, can be very helpful. And the other thing about a contract, which is really great, is a way out, a very clear way out, which is you don't want a vendor to be reliant on you necessarily for income, and you want to be able to give them reasonable notice if you're not happy with the service, or frankly, you find somebody better or cheaper or whatever the case is, or your needs change, and you abide by the rules of the contract. So including a 14-day or a 30-day termination period, saying we have to give you 30 days notice that of when we're going to terminate the contract. We don't owe you anything beyond that. Gives you a lot of financial freedom as well to sign that next contract, and that it makes it much harder for any vendor to suggest that they've suffered any kind of losses or that you've breached the agreement with them. So when you operate sort of freely and it's verbally, that doesn't mean that you're not attracting some kind of legal liability. If you use somebody every month and all of a sudden you cancel them, they might say, I've done work for you for years and now I out a bunch of money and I might go to small claims court. You certainly don't want that. So I, as a lawyer, tend to like very simple contracts for vendors, and those contracts could be just a page. But I think really dealing with the way the term of the fee and how the fee is paid, as well as how you can terminate the agreement. If you have these two things, if these are the only 2 clauses you have in there, you're good to go.
Thank you.
Sure. Okay. And if we have other questions about independent contractors, certainly we can revisit those towards the end of the presentation. I'm now going to move on to, and I'm sharing screen again with respect to employees. So let's talk a bit about employees, federally regulated versus provincially regulated. Federally regulated employees are governed under the Canada Labor Code. They're subject to the Canadian Human Rights Commission, meaning if there is a discriminatory issue, they would file a complaint to the Canadian Human Rights Commission. And they're subject to the labor program. Federally regulated employers are limited to a subset. Most small businesses don't fall in the subset, but it's radio and television or media companies, trucking companies, transportation companies, aviation, banking. So those are federally regulated employers, and those employees are subject to a different regime. By and large, most companies, most small businesses are provincially regulated. That means you're regulated by the laws of Ontario if you've incorporated in Ontario. So that means that you as a business owner need to be aware of your obligations under the Employment Standards Act, Ontario Human Rights Code, what the Ministry of Labor might require you to do. So you could be subject to an investigation by the Ministry of Labor if there's a complaint. The Accessibility for Ontarians with Disability Act, so we call that the AODA, and all employers are required to be AOD compliant in Ontario. And then the Occupational Health and Safety Act. The Occupational Health and Safety Act, essentially the thrust of it is ensuring that all employees are working in a safe workplace. So not only does that mean that there are no razor blades out there, and that there are no sharp edges, it also relates to toxic work environments. And you have every employee has a right to be free from unsafe work environment, which includes violence and bullying in the workplace. So that's also covered under the Occupational Health and Safety Act. And so in terms of the minimum standards that small business owners should be aware of, is vacation time and pay for your employees, notice or pay in lieu of notice in the event that you're terminating an employee, severance pay, the protected leaves, so parental leaves, sick leaves, hours of work and eating periods. So these are typical issues that come up time and again for business owners with respect to your workforce. And what are policies for employees that employers need to keep in mind? Well, I've included here policies that are mandatory for employers to consider of all, well, not all shapes and sizes, there's a couple of caveats. All employers are required to have a workplace harassment prevention policy. And that largely deals with how an employer will investigate issues of harassment or complaints of harassment or bullying in the workplace. So all employers are required to have a policy that deals with workplace harassment, and not just deals, all employers are required to investigate complaints of workplace harassment. And it is a legal obligation, and most employers don't have a workplace harassment policy. So if you don't have one, you would need one. A disconnecting from work policy. So this is mandatory for any employer that has 25 employees or more. Ontario rolled out a right to disconnect legislation last year, which allows employees to disconnect and not have to respond to emails, et cetera, especially if they're not getting paid overtime outside of the hours of work. And so employers are required to have a policy that lays this out and how it's implemented in their workplaces but of course you need 25 employees or more in order to have this as an obligation. Same goes for electronic monitoring. So employers are allowed to monitor employees on their company provided laptops, cell phones, et cetera. But employers are required to inform employees of how they are being monitored. So again, if you have a workplace of 25 employees or more, this is a mandatory. It's not a recommendation. This is actually legally required for all Ontario employers to have. And most employers should have, now they don't explicitly have to have, but we recommend that employers have an accommodation policy. So how you would deal with a request for an accommodation in the workplace. Now, accommodation requests can come in different shapes and sizes. They can be a medical accommodation request. So as an example, I've broken my leg. I might need some help with my desk setup because my chair is just not going to work for me until I've healed. Another accommodation could deal with a psychological or mental related disability. So that could require frequent breaks, changes in work hours, etc. Other accommodation requests could stem from family related protected accommodation requests, like an accommodation with respect to childcare responsibilities. Now, leave policies employers can also consider. Some employers are very keen on rolling out parental leave policies and how parental leaves will be handled if there is going to be a top up for a period of time during a parental leave. That is becoming increasingly popular, as well as sick leave policy. So some employers do offer some paid sick days in Ontario. It is not mandatory to pay for sick days in Ontario. You are required as an employer to allow an employee to be away while sick without any form of retaliation, of course. But you're not required to pay employees for these days. That can be an issue. Some employers believe that they have to pay for all sick days, which is a myth. But many employers elect to provide some paid sick days per year. Now, these sick days that you do pay should be subject to some policy that's clear to employees. So for example, if you elect to provide 3 sick days, paid sick days per year, you may have a policy with respect to how those are administered. Do you need a medical note, for example, to substantiate the leave or not? Most employers do not require those for 3 days. However, for sustained sickness periods, for example, for 3 days or longer, employers may request medical certificates. Now, I wanted to spend a little bit of time talking about the importance of an employee employment agreement. If there's one document that's important, especially for small to mid-sized businesses, when you are onboarding a new employee, it's the importance of an employment agreement. Often employers think about an employment agreement a little bit too late into a negotiation, and often start talking to employees or potential candidates about joining a company, what day they're available to join, negotiating things like salary, bonus, vacation, etc., before turning your mind to an employment agreement. All employers should have a basic employment agreement that has updated termination provisions. If there's one thing I can recommend, it's limiting your termination entitlements to the Employment Standards Act minimums or something close to it. Think about employing a probationary period, especially as a nimble business owner. You want an opportunity to test out employees, see if they're a right fit without a cost to you for a period of time. Confidentiality and non-disclosure. So if you have trade secrets, if you have something that's really important with respect to how you do what you do, if you have really valuable client lists or product descriptions or inventions, confidentiality, non-disclosure are really important, especially if you don't want to lose your workers to a competitor. Non-solicitation, a resignation period, and thinking about what post-employment obligations there could be. Now, I want to just spend a little bit of time on two pieces. One is the termination provision. Why do we care about a termination provision? It's easy to be excited when we onboard a new employee. And we think they're the right fit and they're very eager, and we all call this the honeymoon period. Everything's going hunky-dory. Nobody's thinking about what an exit could look like, but exits happen. And by having a termination provision that we agree to at the beginning, or as a condition to accept the employment, the employee knows what you're prepared to pay them in the event that you have to terminate. So as an example, some employers will offer something like 2 weeks per year of service, as an example, or 2 weeks and a day per year of service. Some employers will say, I will pay you the Employment Standards Act minimums on termination and no more. Now, for most employers, if you have a payroll of under 2.5 million, that's just 1 week per year of service up to a maximum of 8 years. So actually in the first 3 years, it would be 2 weeks. And then beyond that, it would be an extra week per year of service to 8 years. And however, if you have a payroll of over 2.5 million, when an employee works for you for 5 years or longer, you have to pay an additional week of severance in addition to that 8 weeks. So for small and mid-sized businesses, even the statutory minimums, there's something you have to plan for. So some employers don't want to pay more than the ESA minimums because it's certainly something to keep in mind if you are terminating someone. However, if you don't have that termination provision, as I just discussed, in an employment agreement that you hand out to an employee and they sign before they start, if you don't have that, the issue is if you terminate an employee, they can sue employers for a heck of a lot more, much more than 1 month per year of service, which is what people think is the rule of thumb. It's simply not the rule of thumb anymore. So we see short service employees, some of which are working for a year, 2 years, and they're getting up to 12 months or more in court. And Ontario is a very employee-friendly jurisdiction with respect to wrongful dismissal damages, and that's what we refer to as a common law. And so where a contract doesn't govern what an employee is entitled to on termination, the upside risk is really big for employers. So if there's something that you take away from today, if there's only one thing, it's really considering implementing an employment agreement, even if you have current employees that you don't have one for. Finding the right time to implement an employment agreement with an enforceable termination provision can save you a lot of money down the road. Okay, and I'm going to go keep moving on to talking about what a dependent contractor is. I suspect that we might have some questions about employees, though. So I'm just going to pause there for a second and ask, do we have any questions currently about employees?
I do.
Sandra.
Yes, me again. I'm the one with all the questions. I've been an entrepreneur pretty much all my life, so this has happened more than once. And
Great.
what I find, especially now being back in Ontario for the past few years, and hiring seasonal staff, is I want to get back to accommodations requests because
Sure.
I don't know if it's in the food or what's going on, but there's often the problem of anxiety. And they need that space, and it's sometimes it's way too fast paced to accommodate it. And it's difficult sometimes in that maybe they're just in the wrong workspace, but you don't know that until you're deep into, you've done your training, here they are, everybody thinks they're great, and then here we go. The anxiety comes in. So if you could just talk, like I find it difficult in that, but it is a big, like the mental health now is huge, 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 huge. So I'm old school. So it wasn't a subject when I was younger and working, and it's just now it's big on the table. So if you could talk about that a little bit.
Yeah, I actually love the question because it's a touchy one. It's very touchy, and it's something that a lot of employers are grappling with, and it's hard to I think at times deal with maybe what we're seeing as a shift towards, as we've moved towards more of a remote working environment, this focus on work-life balance and boundary setting has become more the norm. And I think employers sometimes are concerned, frankly, that sometimes there are, I'm just going to call it what it is, sometimes a concern that there's a fabricated issue. And so let's talk about anxiety. Anxiety is very generalized. It is a recognized disability under the Human Rights Code. So not to trivialize it, and I'm not meaning to do that at all. But I think as an employer, if you are faced with a complaint or a concern that a worker is suffering from anxiety, the best thing you can do, and this is not being intrusive, this is doing your job. It's asking that person for information from their doctor about how to accommodate them. And the best way to do that is a restrictions form, a restrictions and accommodations form. So often employers will say, look, we have this issue. We have an employee who is potentially raising an issue that we think could raise liability for us. So a restrictions form is essentially, doctor, could you, without giving us a diagnosis of this person, because by the way, you as an employer are not entitled to the private nature of a diagnosis or right. So it's very delicate because there's only so many questions you can ask, right? And you know this. So because of that, you provide the form and you say, I'm not asking you about the diagnoses, doctor, but I'm asking you about the restrictions and the accommodation, any suggestions about accommodations for this employee. And that squarely puts the employee to the task of going to their doctor, having a conversation, seeing if there's really, something to be filled out here or not. And that's how you're going to really legitimize whether or not this is a true ask or not. Some employers are worried about doing these restriction forms or accommodation forms, but I think it really does limit. It sets a really good standard within the workplace, which is if there's going to be a sort of vague related complaint about potentially the level of the work, the nature of the work, if it is anxiety inducing, okay, well, here is the solution. I need to know from your doctor what you can and cannot do and how long you need these accommodations in place. So for example, there might be restrictions like, well, so-and-so might need a break every 2 hours. a break away from the computer. Sure, I can accommodate that, no problem. It probably wouldn't affect their productivity at all by allowing that to happen. So I think that making sure the employee is participating in the accommodation is really key, because otherwise employer feels like they're owning it entirely, not knowing how to do it. And you
Mhm.
wouldn't know how to do it. How would you know how to do it? You're not a doctor. I'm not a doctor. It's only a doctor filling out this restriction and accommodation form that'll help you do that. But it also puts a time limitation on this, so you're not worried about, first of all, not addressing the issue, because I think once the employee raises this issue, there's absolutely a legal obligation on the employer to ask questions. It's a duty to inquire. And so I think providing an employee with this form, go to your doctor. And I will say that I call it anecdata, because I haven't done a study, but for the employers that I've worked for, in this sort of situation, a lot of employees don't hand one back because they actually haven't gone to their doctor about it. They actually don't want to go to their doctor about it. And the issue seems to, solve itself.
Good. I've
Okay.
never done a restrictions form or an accommodation form, but I've always been like a seasonal worker, like all the business I ever had, you could close in the winter. So, but it's definitely an issue, and it's big, and it's everywhere. So just wanted to
I agree.
get a
It's
way
a
to
big
handle that.
one, and it's a chronic one. And I think it's chronic more so now, because more people are working remotely, they're feeling more isolated, the level of satisfaction in the workplace has gone down. And so you've hit the nail on the head. It is absolutely, it's a concern that a lot of employers are dealing with, but I think having the right tools to respond quickly and having a very robust but straightforward process that you can actually manage is really key. So again, it's not super disruptive for you. So I love the medical restrictions form. Sometimes you need it. Okay, so I'm gonna
Good to
jump
know.
right back
Thank you.
in here to dependent contractors, and which we call the middle ground. So it's intended to cover workers who provide services as contractors, but rely on one client for all or nearly all of their income. So I gave you this example earlier of a nurse working at a hospital, but also working for a private doctor's office and maybe a private family. So courts look at the same factors of that of an independent contractor, in large part the level of control, the level of exclusivity, as we talked about earlier. The emphasis on exclusivity and income generated from the client, so earning substantively more than one, for example, over 50%, will weigh in favor of being a dependent contractor. And the level that the contractor is integrated within the company, so if they have a business card, they expect to earn a profit from the service provided. It's provided with the tools and equipment, and the contractor's work is part of the principal's business. So dependent contractors, in some cases, have similar claims to that of an employee. So they might have a roster of clients. They might have 6 or 7 clients, but if they earn over 50% from one organization, and let's say that organization changes the nature of the contract or cancels the contract, that could give rise to a breach of contract claim by this contractor, and the contractor takes the position that they're a dependent contractor. So they'll say, it's going to take me a long time to replace this income. Over 50% of my income comes from you, and I'm going to sue you for the breach of the contract or for terminating the contract with me. So having a robust contract dealing with these types of issues is imperative, especially even if you're working with somebody half-time, or if they're working for you 20 or 30 hours a week. Thinking about the end of the relationship or the possible end of the relationship can be a very savvy business move, because the courts certainly recognize this middle ground as well. It's not full-time or nothing. Certainly if somebody's working for you 20 hours, 25 hours a week, they might be found to be a dependent contractor, even if they have other clients on the side. Legal implications of defining employees versus contractors. So lots of text here, but I'm going to go through it as quickly as I can. The legal implications of defining an employee versus a contractor is the wrongful dismissal suit. So believe it or not, even if I want to be an independent contractor, and even though I work with you for 40 hours a week, but I say, no, 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 I want to be an independent contractor. I don't want to be an employee. I want to invoice you. The fact of the matter is, if I'm an employee, and I actually work in your workplace, and I should have been defined as an employee, the court's going to do a correction for everyone, regardless of what the parties may have agreed to. So this usually blows the minds of most individuals, because they'll say, well, the two of us agree that he's not an employee, the court shouldn't step in. The court step in because they don't want employers taking advantage of what would-be workers that should have protections under the Employment Standards Act. And so people need to be careful about creating independent contractor relationships, because the courts could step in and deem somebody to be an employee anyway. And that could cause a lot of administrative nightmare, as well as increased damages for employers. So there could be bad faith and aggravated damages as well, especially where Employment Standards Act minimums were not paid in time or at all. If you terminate a contractor who is really an employee, if you haven't issued a record of employment, there's no termination letter. And the other factor I think we need to consider here is, if you let go of a contractor and you never paid them for vacation, there are a lot of benefits to being an employee that a contractor doesn't get, but if they're later found to be an employee, an employer could be dinged by it. Now, employees on the other hand, if they are an employee, they can go to the Ministry of Labor, raise issues and complaints with the Ministry of Labor about the workplace. Ministry of Labor can launch an investigation into complaints around only the minimum standards required under the Employment Standards Act, but it could certainly create some disruption in the workplace. More often than not, we see Ministry of Labor complaints arising from the failure to provide vacation time, overtime pay, failure to comply with meal times and hours of work. And if you're terminating someone without providing them with the termination and severance pay that they might be entitled to under the Employment Standards Act. It's a responsibility of the employer, by the way, to deduct CPP, EI, and income tax. And so there might be additional liability if you call someone an independent contractor and they bill you every month and they charge you HST and you pay that. But if they were truly an employee, well, the CRA wants you to deduct from the source. It's your responsibility as the employer actually to tax these individuals appropriately and remit to the government. And so the CRA could actually impose a penalty as well if you misclassify an employee as an independent contractor. So there's another incentive to call an employee an employee. So how do we reduce risk? So where we talk about limiting exclusivity, showing intent in the contract. So first of all, think about exclusivity from the outset. If you want somebody to be a contractor, that means you certainly want your contract to speak to that. If they're free to engage in other business, that should be spelled out. So the nature of service clause is certainly helpful in this regard. It's defining the nature of the relationship. That can be helpful that both parties show the intent to the contract. I did say before that that's not the be all end all. Courts will ignore that if it's somebody's truly an employee, but showing the intent that both parties agree that that it is an independent contractor like relationship will help. Defining the service to be provided is also helpful, because you want not only that the service is being defined, but also the way the service is being provided, that the person is using their own tools, they're doing it on their own time. How else can we reduce the risk? Defining the term. So the term of the agreement, it could be for a 1-year term. It could be on a casual basis. I really like casual bases, which is we'll give you the work when we have the work. So just because we give you a project today doesn't mean a project is coming up again once the project is done. It really confirms the casual or project-based nature of the work. So you want to be careful about defining the term unless you really believe that the person is going to work for the entire term. So if you are defining the term, define it as narrowly or as short as possible. For example, a 3-month term, a 6-month term, even try to get away from a 1-year term, make it much shorter if you are defining the term. Confirming the contractor's tax liabilities is important. So here we have a sample clause: the company shall not withhold any amounts for provincial or federal income tax. So you're leaving it on the contractor to pay for their own federal tax, and you're having them agree here that they're going to indemnify you with respect to any CRA implications, and how they deal with their taxes is not your business, it's theirs. Another way to reduce the risk here is having a termination section. So I have here that the company and the contractor, for example, can terminate the agreement upon 2 weeks written notice. So this is a sample clause here of how to deal with a termination of a contract. And even if, excuse me, the contractor is found to be an employee, they're still limited to the Employment Standards Act minimum. So this is a really cool way to limit your liability. Even if if a contractor is found to be an employee, you can contemplate that in your independent contractor agreement by actually limiting them to the Employment Standards Act minimums, as I've done here. So I've provided you today with some sample clauses, as you can see, of flipping through here. A lot to take in, I'm sure. And I wanted to leave a few minutes for any other questions we may have today. And in particular, I've gone over some sample clauses for an independent contractor like contract. I haven't done that for an employment agreement. If that is something of interest in terms of what sample clauses could be included in an employment agreement or what to look out for, certainly we can discuss that in the question period or even for a follow-up webinar. And I see that we've added a link to the chat already with respect to questions that you may have. I'm going to ask anybody now if there's anybody who'd like to ask a question about any of the content today.
That slide there about the, I don't know what slide that was. Can you explain the thing on electronic monitoring? What is that?
Electronic monitoring, sure. So I think I'm just going to flip back here. So here we go. Policies for employers. Sorry, I'm going to remove that. Policies for employers, electronic monitoring. Yes. So electronic monitoring is a policy that you're required to have as an employer in Ontario if you have more 25 employees or more. What that means is that if your employer is doing any form of monitoring of employees, so here's an example. If there is software on your workplace computer that is being used, for example, to track productivity, if they have access to your emails or the network, if you have a cell phone, if there's GPS or other data that's being collected about you, employers are required to have a policy that informs employees that electronic monitoring is happening and in what form. So employers are permitted by law to perform some levels of electronic monitoring of employees. So as an example, on your workplace email, employers have access to that email and may from time to time review that email. So employers are required to actually let employees know in writing that there is an electronic monitoring policy and that they may from time to time monitor whether it's the work product, whether it's emails, whether it's the location data or other data from workplace devices.
That's for employers that are 25 or more employees, right?
That's correct.
But aren't federal employers exempt from that? Like banks don't need to notify their.
It's provincial legislation. You're right. So this is for Ontario. It's in the province of Ontario. So this is with respect to provincially regulated employers.
Okay, thanks.
Yes. And I think I saw a question from Nilu.
Yeah. So I have a question. If suppose there is a limitation of a timeline, suppose 500 hours for one project.
Mhm.
And so on the paper and verbally, if we do the both agreement or talk, it's the same thing, because on the paper is a 500-hour project. If you go beyond, because there is some need to do more and you spend more hours. So because if you're working is, dependent contractor. So I'm not sure, should we sign up some paper, because it happened before and I worked like more than 500 hours, but okay, we don't have money and we will provide you. Can you just do for a volunteer? And it's not by written and verbally. So I was just wondering how things will proceed, because I did not sign up any, just contract, which one they send me as a depend contractor, not independent, depend contractor. So I signed up the paper, or like their paper. So, but I was not sure. I did the work, but it's beyond like 40 hours, 50 hours. Yeah, more than my capacity as a volunteer. Should I sign up or do my own paper before sign up anything?
Okay, that's a really good question. So I would say use email as your friend here. You don't need anything really formal. I would say the first thing you should do is write a very simple email that you've gone over the 500 hours, give an estimate of what you think the time is. So if it's 540 hours, 550 hours, you should not agree to do work as a volunteer at all. And I would propose how that additional time should be compensated. So you may propose that if you divide the fee by the 500 hours, you'll get an hourly rate. So you might say, pay me the extra $53 an hour for the 40 hours I've worked. That's an example. Or, going forward, you may very well want to consider what an overtime rate would be in the event that a project goes overtime. So you may say, traditionally, for this 500 hours, this is going to be the rate, but I'm going to apply 1.25 times if we go over that time. And you should probably think about that going into the future, but I would never advise anybody working for free or agreeing to anything on a voluntary basis. So use your email. Certainly you want to document this, take it out of the verbal context, move it to something in writing that they would have to respond to, because if they end up not paying you, you now have a written record that you could rely on later, especially if you need to consider enforcing that payment in some way. So you may go to the Ministry of Labor as an example. You may consider some legal action, and it would help anybody working with you to establish the chain that you actually asked for the payment and then you were not paid.
Thank you so much. Thanks.
Sure. Okay. Any other questions?
I was gonna say, as much as I'd love to take another question, we do actually have another webinar in here
we're
in about
12.
5 minutes. Yeah. But thank you so much for the wonderful presentation today. I have also put your information in the chat. If anybody would like to email, call, or check out Sunira's website, it's there in the chat. If you would like a copy of today's recording, please feel free to send me an email at communications@pero.ca, where all the recordings for the webinars, regardless if it's this one or any you've missed, you can watch them all in a playlist when you have a chance. Also, I would love to invite you all to our International Women's Day event on March 8th. It is a hybrid event, so you can attend it from anywhere across the world virtually, or we'd love to see you there in person in North Bay. The link is in the chat. Tickets are $10 for online and $45 for in person. But otherwise, thank you so much, Sunira, for the wonderful presentation, and we'll see you all at our next webinar. Bye-bye.
Bye.
Thank you.